All right. Good afternoon, everyone. Thank you for joining us today. If you're still kind of coming in, getting settled, that's totally fine. We're just going to kind of read a brief intro about Standpoint and kind of introduce our presenters today. My name is Jay Fortune. I'm the office manager here at Standpoint. My role today is going to help facilitate the webinar. So if you have any questions during the presentation, please type your questions in the Q&A tab, or you can use a chat box as well, and I can pass the question along. Most of you probably are slightly familiar, at least with Standpoint. But for those of you who aren't, Standpoint, we are a statewide organization. We're a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who work with survivors. We do this by facilitating trainings and answering calls to our action line. Examples of trainings we have are our annual new laws throughout the state of Minnesota, which save the date. The dates are on our website if you want to check that out. Our registration will be open in July. We also have monthly webinars for advocates just like this one and other trainings by request. Our action line is answered Monday through Friday from 9 a.m. to 4 p.m. And it's through our action line that our attorneys provide legal advice to survivors and our advocates connect callers with resources, safety plan, listen, and help callers identify possible options and next steps. This webinar is being recorded and you can check it out on Standpoint's YouTube page. The link to the recording will also be emailed out to our Standpoint Legal Advocates listserv after the webinar. For today's presentation, I did put in the chat box the link for the PowerPoint. I'll send that again for folks that have joined and missed it. And now I want to introduce our two presenters today. First up, we have Rachel. Rachel Kohler went to law school at Hamline University and has been working primarily in immigration law since 2009. For many years, she volunteered as a GED tutor, a refugee resettlement coordinator, and organized activities at a juvenile detention center. Her experience working at the International Institute of Boston, a nonprofit immigration clinic which provided immigration assistance to victims of various crimes, including domestic assault and trafficking, provided her with a desire to attend law school and become an attorney. As an attorney, Rachel worked at Southern Minnesota Regional Legal Services, providing assistance to those going through the citizenship and naturalization process. Sorry about my cat here meowing, if you can hear that. And has clerked at the immigration court and at several private immigration firms. Rachel worked in Anoka County for 2 years and dealt directly with civil, family, and criminal cases. Rachel joined Standpoint as a staff attorney with an immigration focus, and she received her bachelor's degree from Concordia College in Moorhead, Minnesota, in Spanish and Global Studies. Rachel is bilingual in Spanish and is from Worthington, Minnesota and Fargo, North Dakota. And then also with us today is Victoria. Victoria is a law student at the University of Minnesota with a focus in immigration law. After graduating from college in 2017, Victoria worked as a paralegal with a private immigration law firm in Minneapolis, assisting with a wide variety of immigration cases, including asylum, citizenship, employment visas, family petitions, and bond requests for people in immigration detention. She also volunteered in an adult ESL class at the Hub Center in St. Paul. Her experience working with immigrants and their families strengthened her desire to pursue a career in law. While attending law school, Victoria has continued her immigration work, volunteering on asylum cases for the Advocates for Human Rights and joining the immigration program at Standpoint this summer through a Minnesota Justice Foundation fellowship. She received her bachelor's degree from the University of Minnesota Twin Cities in psychology and gender studies, which is with a Spanish minor. She is bilingual in Spanish and is from Prior Lake, Minnesota. And so now I'm going to pass it off to Rachel and Victoria.
I'm just going to give a quick sort of intro into Standpoint before handing it over to Victoria to get into some of the family-based immigration law overview stuff. Our mission, as Jay kind of already talked about at the top, is to promote justice for domestic and sexual violence victims in Minnesota. This is a weird presentation for me because this presentation is not about relief that you can get, immigration relief that you can get based on being a victim survivor of domestic or sexual violence. We've done those presentations. Please see our catalog of webinars. I've done presentations on U visas, T visas, VAWAs, other applications. But we're not talking about that today because I kept getting calls from advocates and survivors through our action line asking questions like, my US citizen child just turned 21, can they petition for me? Or, you know, I've I've left an abusive relationship. I'm in a good relationship now. We got married and my spouse now wants to petition for me. Is that an option for me? I have a sibling that just got their green card or just got their citizenship and they want to petition for me. What does that look like? And so this presentation is going to be about sort of other immigration relief that might be available to the survivors that you're working with as advocates. The concepts that we're going to talk about today are difficult, they're complex, and Victoria and I worked really hard to try and pare it down as best we could. And I know I'm stepping on you a little bit, Victoria, you're talking about that in the next slide. But just know that some victim survivors you're working with may not want to pursue a victim-based application for a variety of reasons. They might not be eligible. It might be too re-traumatizing to report to police or to go through that process. And so they might be looking for other options like family-based immigration. Or maybe they did apply for a victim-based application, but that's going to take a decade to process, and they want to see if they can get immigration status faster. So that is more or less why we're giving this presentation here today. And so I'm going to hand it over to Victoria to sort of talk about, was the next slide you, Victoria? Yes?
Yes,
Awesome.
So I'll take it away. Thank you, Rachel. So I'm really excited to be here today talking to you all about immigration. And as Rachel mentioned, this is a different type of presentation than Standpoint would normally give. So our goal today is to do a little high-level overview of some of the non-victim-based applications that might be available to certain immigrant victims. We're going to go over the basic requirements and the complications of family-based immigration petitions as well. So as Rachel said, immigration is very, very complicated, and we did what we could to keep this simple. So the information here is simplified, and it's very general. So we did our best to be accurate without overwhelming you with details. However, this presentation is not intended as legal advice, nor are we expecting you to be giving legal advice on immigration or any other matter to the people that you're working with. Even if you understood everything in this presentation perfectly, just know that the field of immigration is complex and constantly changing. So new things happen all the time, and it can really change the game for someone you're working with based on a little detail of their past. So anytime you have a question or some of the things in this presentation seem to be coming up for someone you're working with, consult with an immigration attorney. Send them to someone like Standpoint or another nonprofit so they can really delve into the details of their case. With that said, let's get started. So to start, a little overview of the different types of immigration. So you can see on this slide different paths people might have to get some type of status or immigration benefit in the United States. Some kinds of immigration are temporary and some of them are permanent. So common ways that people will get this type of status or benefit would be family sponsorship, sometimes called reunification. That's what we're going to focus on today. They can also do so through employment, when a specific employer sponsors a visa or a green card. You can get status as a student based on your admission to an educational institution. You can get status as a refugee or as an asylee. This is for people who are fleeing persecution or violence in their home country. Refugees apply from outside and asylees apply from inside. There is something called the diversity lottery. This is the closest to what people think of as sort of getting in a line of wanting to immigrate to the United States. The diversity lottery allows a certain number of visas to be given sort of at random to people who apply from countries who have had a historically lower amount of immigration to the United States. So these are also going to be people applying from outside the United States. There are certain kinds of humanitarian immigration for people who have some type of emergency in their home country, something like there's an earthquake. The United States might designate that country as a place where people aren't safe going back to, and give them a temporary status. Or they might be allowed to enter the US because there's some type of emergency specific to them and their family. I also put DACA here on the slide because I know this is in the news a lot. So you may or may not have heard of this one, but DACA stands for Deferred Action for Childhood Arrivals. And it's a way that certain people who came to the United States without status as children can apply to get protection from deportation and permission to work. One thing to know about DACA and a lot of other types of of temporary status is that they're not permanent. So people with DACA do not have a path at the moment to apply for a green card or citizenship based on having DACA. So it really is kind of limbo, despite the fact that it does have benefits that come with it. The next one is what I expect you're most likely to have heard of, given your role working with victims of crimes. But there are types of visas like U visas, T visas, and then VAWA applications that are based on being the victim of a crime, trafficking, or domestic violence. Another weird one I wanted to point out is J visas. These are temporary visas, sometimes for students, sometimes for employment. The reason they're on this slide is because Standpoint has gotten a couple questions about J visas recently. So we just wanted to point out that it's a particularly odd type of visa that's complicated and sometimes has requirements about leaving the country for a while. So if anyone has or had in the past a J visa, definitely have them talk to an immigration attorney about that. Finally, there are some kinds of relief, so a path for status that's available just to people who are in immigration court. And of course, there are more than this, but this is a general overview to give you kind of an idea of how people would get to status. Some people might qualify for different paths, and they pick the one that's the fastest, the cheapest, that they're eligible for based on their criminal history. It really depends why someone would pick a specific category. But today we're going to focus in on the family sponsorship and reunification. So as I said, and as we will continue to say, immigration is very complicated. The process looks different if someone is applying from inside or outside the United States. It also looks different if you're in what they call removal proceedings, which basically means you're in immigration court. So whether you were put in proceedings right away when you talked to a border official when you crossed, or if you were served with something that started proceedings many years later. That is a whole different world through the court system versus people who have never been in proceedings. So today we're focused on that not in proceedings side. There's also a difference based on whether you're applying for immigrant or non-immigrant status or benefits. That's what I was mentioning before about some things that are permanent and some things that are temporary. So we use the term immigrant and immigration very generally in daily conversation, but in immigration law, immigrant really means green card or lawful permanent resident. That's what that acronym is. This is a status that's permanent. It gives you work authorization to work for anybody that will hire you, and it gives you a path to citizenship after a certain amount of years. On the other hand, there are non-immigrant status. A non-immigrant status is going to be temporary. It may or may not have work authorization, and it might be just for one specific employer. And it maybe has a path to a green card, never to citizenship. I know some people get a little confused and they think if someone doesn't have status, they should apply for citizenship. But everyone who gets to that stage of applying to be a citizen first needs a green card. So today we're talking about people who are physically inside the United States, who are not in immigration court, and are applying for that immigrant status, their green card, specifically through a family member. So we have a lovely graphic here, family-based immigration. As I said, this is a process that allows somebody to be sponsored by a family member. So a US citizen or a permanent resident just sponsors a green card for somebody. We're going to go over briefly, what does a sponsor do? Who can be a sponsor? What are the steps involved? How long does it take? And Rachel will cover what if a family member wasn't legally admitted, get into some of the complications. So the first one, what does a sponsor do? It sounds kind of intimidating, I think, to some people. What do I have to do to sponsor a family member's green card? But it really boils down to 4 things. 1, they have to physically sign the application, tell immigration that they are sponsoring their family member. 2, they have to provide biographic data and identification documents. They're going to be giving things like their address history, employment history, date of birth, and copies of their passport to show their status, all that kind of stuff to immigration. 3, they need to prove their ability to financially support the intending immigrant. That's their family member. This is something that I think causes some anxiety for people who want to help their family members, because there are requirements about how much money you need to make or how many assets that you have. But I want to point out that the requirement here is proving your ability to financially support, not proving that you are giving them money or even that you will. Essentially, this is a way for the government to say this person will not need public benefits. If they can't support themselves, someone has said that they can help. And we'll talk in a little bit about the details of how this works. There are some options if the family member doesn't have a lot of resources. 4, the most important thing, a successful sponsor needs to maintain that family relationship until the immigrant's green card is actually approved. This is really easy if you're applying for a parent. They're going to be your parent, whether they're speaking to you or not. But for marriages, you still need to be married at the time that that green card is approved. Otherwise, you cannot have your green card approved based on your marriage. So they don't look at when did you file, they look at when we're going to stamp approved on your application. So who can be a sponsor? US citizens and permanent residents have to be an adult. And by immigration standards, that's actually 21, not 18. Who you can sponsor is broader for citizens versus permanent residents. So if you're a US citizen, 21 years or older, you can sponsor your spouse, an unmarried child. Immigration defines child as under 21. Unmarried son or daughter. Those are the words that immigration uses for someone who is your child but is over 21. You can sponsor married sons and daughters. Again, they need to be over 21 for that qualification. You can sponsor a parent, and you can sponsor a sibling. So you'll notice the list is much shorter for permanent residents. These are people who have green cards in the United States. They can sponsor a spouse, unmarried child, again, that means under 21, or unmarried son or daughter who are over 21. So you'll notice if you're the kid of a permanent resident and you get married, there is no longer a way for them to sponsor you unless they were to become a citizen.
There is a question. Is that okay if I share?
Yeah,
now?
absolutely. What's the question?
It is, how long is it taking for USCIS to process applications for a spouse?
We are going to get to that in a couple slides. So I will tell you to hold on to that question in just a second. I'm going to first talk through what are the steps, and then we have a couple examples of the processing times. If you're not able to stick around for that question, I will say that USCIS does post their processing times online and update them frequently, but I'll show you some examples in a minute. So I'm going to go over the basic steps of family-based immigration, specifically for intending immigrants who were what they call lawfully admitted. Essentially, I'm going to be talking about what happens if somebody entered with a visa of some kind. Admission means a legal act that the government gave you permission to enter and be present in the country. This is separated in immigration law from an entry, which is simply the physical act of crossing into the country. So somebody may have entered without being admitted if they crossed without paperwork, for example. But if you're admitted, then you have also entered. That has to go together. So if you came in with status, whether or not you still have it, if it expired and you're still here, then this process still applies to you. So there's 3 things up on the top level here, and these are all forms and documents that you file with Immigration Service. Then there's 3 things on the bottom of what happens after that. But the big work for the immigrant and their attorney is putting together a package of information and the forms to send to immigration. The first one, you can see the picture of the people. It's kind of how I like to think about it. You have to ask immigration to verify your family relationship. So you file what's called Form I-130 along with evidence of your relationship. Really easy if it's parent-child, send a birth certificate. More complicated if you're petitioning for a spouse. Then you need to show not only are we legally married, but it's what they call a bona fide relationship. It was in good faith. So things like, here are pictures of us on a date, letters from friends and family. Here are proof that we have combined bank accounts, filed taxes together. You're trying to prove that you've melded your lives and not married for immigration purposes. The second application that you file in the middle, Form I-485, this is really the green card application. So this form mainly just has the immigrant's information on it, a lot about their demographics and their immigration history and copies of their identification documents. The next thing, my little piggy bank, this is what I was talking about, that the sponsor has to show ability to support. So Form I-864 is the affidavit of support. And the sponsor would send in their financial documents, such as taxes, or maybe supplement with bank accounts, if they own property, things of that nature. Now, when you filed all that with immigration, they will send you an appointment to do your biometrics. So they're gonna run a background check that requires fingerprints, taking a picture, and eventually they will ask you to do a medical evaluation as well that you submit to immigration. Next step for marriage petitions only. So only if you're applying for a spouse, you have to do an interview with immigration. And again, this is where they go over that proof of bona fide relationship. They'll talk to you about how did you meet, what's your relationship like, what you know about the other person, really just trying to make sure that you're a real couple. If all that goes according to plan, wait for immigration to actually get around to your application and the long list they have, your green card will arrive in the mail. So, as I mentioned, this is all filed with the Immigration Service, technically called USCIS, stands for U.S. Citizenship and Immigration Services. So here again, I just wrote out the names of those forms that you need to file and a couple notes. There's an additional form, I-130A, if you file for a spouse. When you file that green card application, you do have the ability to also request temporary work permit, social security number, and a travel permit. And then, as I said on the I-864 sponsorship, if someone's assets, your family member's assets aren't enough, there is an option for them to include a co-sponsor, somebody else with status to step up and say, I will also use my taxes or bank accounts to reach the requirement here. So if you want to look at any of these forms or the instructions, they're all available online. The USCIS website is there at the bottom, and they do include very detailed information about how these forms work and what you need to have. So on the right here, I have the two different ways that people get to file all of these forms. So the first way, which is really what you want to do if you can, is what they call the one-step application. You file everything together. So all of your forms, all of your evidence, it's all going to go to the same place at the same time. This is the fastest process. However, not everyone is eligible for this. So if you can't do that, then you do a two-step process. The first thing you do is file the Form I-130 to prove your relationship. And then when you're able to do so, you file the I-485 green card application along with the affidavit of support as your second step. So the big question, how long does it take? Nothing in immigration moves very quickly. So even the fastest process, it does take a while. However, it's going to be faster or slower for family-based immigration based on the status of the sponsor, whether they're a citizen or permanent resident, the type of family relationship, if you're applying for a spouse versus a child, and the nationality of the intending immigrant. Visas for immigrants are limited by country, a certain number each year in some of these categories. So if a lot of people are coming in from a certain country, their wait list is going to be longer and it will take more time from those countries. So I'll show you how to check that in a second. So the fastest process, the best case scenario, is immediate relatives of US citizens. This covers parents, spouses, and unmarried children under 21 of US citizens. This is the fastest process because you get to file all of your forms at once. It's that one-step application I mentioned, and there's no waiting list. So immigration does not put a limit on how many immediate relatives can get a green card each year. So the only thing you're waiting for is immigration's process. There's no step where they put you on the shelf until your number is called. But still doesn't mean it's fast. So the current processing times for our local field office, if you live in Minnesota, The Minneapolis-St. Paul field office is taking from 14 to 21 months to process these applications. So you're looking at 1 to 2 years from the moment they receive your paperwork until they're sending you your green card in the mail. These processing times are always subject to change, but they're updated frequently on uscis.gov. You can search by type of form and the place that it's processed to see how long it's currently taking them to finish a form. So people who are not lucky enough to be the immediate relative of a US citizen are going to be subject to some type of yearly limit on the number of visas that can be given in that particular category. These wait times are also posted online. The Department of State publishes something called the Visa Bulletin. So you can go to the Department of State website, travel.state.gov, search for Visa Bulletin and click on the current month. Honestly, I usually just Google June 2021 Visa Bulletin, pops right up. And then you're going to get a web page, but you can also open it as a PDF. It's not necessarily a fun looking document, but we're going to talk about how to read it. So the first thing that you always need to do when asking how long is this going to take is identify what is the preference category. So on the Visa Bulletin, I took a screenshot here, they list all of the preference categories other than those immediate relatives. So you can see, okay, first preference, unmarried sons and daughters of US citizens. And then you look down at the third, married sons and daughters of US citizens. So it's just going to explain based on your relationship, what category are you in. So I start here. The next step is to look at this table called final action dates. A final action date is the date that immigration can stamp approved and give you that green card. The dates here reflect the date that you filed your I-130 application. So when you send that I-130 application to immigration, they mail you back a receipt. This person filed this application on this date. Here's the number that we assigned to it. You're going to hold on to that receipt and wait for the date listed to match the date on this chart. So you can see here, like family sponsored F1, if you go to just the first category, it says November 1st of 2014. So I would have to have been holding on to my receipt since November 1st, 2014. And I would know, okay, now they can approve my case. It's been long enough. The C's that are listed on this table just mean current. So that is a very good thing to see. If there's a C, it means it works like the immediate relatives of US citizens. Send everything at once, and you only have to wait for their processing times, no additional wait. This part is a little more complicated, and we're not going to go too far into it, but I just wanted to make sure you understood that when you do have a waiting list for your category, as I said, you can't do that nifty one-step application where you send everything at once. Instead, you're doing a two-step. This chart, the dates for filing, tells you when you can do your second step. Because it's going to take years and years for immigration to work on this, they don't want to hold on to your green card application that whole time. So instead, you wait with your receipt notice from the I-130, and when the date on your receipt notice matches the date on this table, you can file the next step of your application. Okay. Now we're going to go through a couple case examples to kind of apply that knowledge to some hypothetical people who want to file for their family members. So in our first example, we have a US citizen adult daughter who's filing for her mother who's from Mexico. The first step is we have to think, what category is this? And then what is the wait time for that category? Here, daughter filing from mother, as long as the daughter is a citizen, this is an immediate relative category. So you don't even need to go to the Visa Bulletin. Don't have to worry about it. You know that there's no additional wait. Because there's no waiting list, you file everything together with that one-step application. And again, the current processing times for our area is at 14 to 21 months, 1 to 2 years for mom to get her green card. Now, if we flip that scenario around, instead we have a US citizen mother filing for an unmarried adult daughter, so somebody's over 21, and the daughter is from Mexico. Again, first step, what category is this? because it's not an immediate relative, we have to go and look at the visa bulletin. So the category here is going to be the first preference category, F1. So it's an unmarried daughter of a US citizen. Now that you've found your category, go to the final action dates to figure out how long is the case going to take overall. So we start with the row for our category. Now you have to look and say, is the country that this immigrant is from listed out separately, or is it just everybody else? Well, here we said the daughter is from Mexico. So then you need to look specifically at this box here. And you'll see, unfortunately, these applications are taking a really long time. So the date is May 1st of 1998. This means you're looking at about 23 years at the moment from filing your I-130 to actually getting your green card. And you have to do that two-step process. Next, a US citizen filing for their adult brother from India. The category for this one is fourth, so F4, brothers and sisters of adult US citizens. Now we're going to go to our final action dates to figure out how long the whole case takes. Start with that whole row, and this person is from India, so you know you have to use one of the special categories. The date we have is May 8th, 2005. Still a really long time, but much faster than our last example. So this person is looking at around 16 years. And again, because the wait list, you have to start with the I-130 and wait to file the rest of your paperwork. All right, our last example, permanent resident filing for a spouse from India. So the category here is F2A, spouse of a permanent resident. Go to the final action dates, and you'll see good news. We have all C's across the board. Remember, C means current, so there is no wait list for this category. Good news, you can do your one-step application, and you're looking at that 14 to 21-month processing time. All right, unless there are any specific questions about that part of the process, I will turn it over to Rachel for when things get sticky.
Victoria, that was beautiful. You explained that wonderfully. I'm getting very nervous now about my section because exactly as you said, this is my section is going to be about when things are less clear. There's not going to be an easy chart to be able to, well, not that the visa bulletin's an easy chart, but there's not really a chart to go to map whether or not someone is considered inadmissible or eligible for a waiver. So the section I'm about to step into is about inadmissibilities and waivers. So basically, when somebody is being petitioned for by a family member, utilizing the process that Victoria explained in the previous slides, I'm going to talk about the problems that they might encounter when they're trying to gain admission to the US and the possible ways they could solve that through a waiver. Again, the caveat to all of this is that the process of identifying inadmissibilities and determining eligibility for a waiver is super complicated. It needs to be done by an experienced immigration attorney. So I want to do this part of the presentation. It might seem a little overwhelming as I go through it. It's okay, it is overwhelming. It's more to just open up your ideas and your mind to these concepts, especially if you are going through, if you're working with a victim survivor of violence who's going through a family-based process or is looking to go through a family-based process, and they're working with an attorney and they're just not understanding. This might be a really helpful way for you to better guide and support them through that process because you've heard of some of these things now. And certainly come back to this presentation as you need to, or the slides as you need to, call Standpoint as you need to if these things come up and you're like, hey, I remember a little bit about a thing in a presentation once. I'm going to call Rachel and follow up on that. All right, go ahead to the next slide. Okay, so first I'm going to talk about what inadmissibilities are and why they're important. So the first concept that I just want to drive home is that to immigrate to the United States, you have to satisfy two general ideas. The first is that you must qualify for that particular means of immigrating. So that's the section that Victoria talked about. You have to have that qualifying relationship to that family member in order to be able to be petitioned for through the family sponsorship process. The second part, which is really important, is that you must be deemed admissible. It's a really important legal concept in immigration law, but how I kind of like to explain it is that Congress has created a list. There's a big book of laws called the Immigration and Nationality Act. A section in that Immigration and Nationality Act is a whole list of things that Congress has decided would make you inadmissible, or things that would keep somebody from being able to immigrate to the country. They've designated these things as, we don't want people who have these things on their record to come into the United States without at least getting it forgiven first. And so I'm going to talk about some general grounds of inadmissibility, but there's quite a lengthy list. You can certainly dive into the Immigration and Nationality Act should you choose. I'm going to dig into one particularly prominent one in this presentation, but some of the general categories of inadmissibilities are through health-related grounds. So this could be if you have a communicable disease, if you have any substance abuse issues, that could fall under health-related grounds. Criminal-related grounds, I think that's the one that we're probably most familiar with. If you have convictions of certain crimes, in particular drug crimes, prostitution crimes of dishonesty, are crimes that are looked at really seriously by immigration. There are exceptions to some of the crimes, but certainly if you're working with someone who has a criminal history, it's important to talk to an immigration attorney to determine if that's an inadmissibility. National security grounds could include things like terrorism or espionage. Public charge, I think that we've all probably heard of as well, is when immigration has deemed a person likely to become dependent on the financial support of the government. And so immigration has very specific categories that they go through to determine whether or not someone is deemed to be a public charge or not. Immigration violations grounds, so this could be alien smuggling, which could include, coyote bringing people across the border, but could also include crossing the border with family members. That could encompass alien smuggling. Also, if you utilize any fraudulent documents in order to get an immigration benefit, or you have a false claim to U.S. citizenship, that would fall under the immigration violation ground of inadmissibility. There are certain documentation requirements. If a person needs to maintain or have documents indicating that they have authorization to remain in the United States, if they don't do this, then they're in violation of that, and that's an inadmissibility. Strangely enough, if you don't have a valid passport to your country, if you let your passport expire, you don't have a passport, that's also an inadmissibility. Prior removals or unlawful presence. This is the category I'm going to talk about in particular, because as Victoria said when she was explaining what we're presenting on today, we're focusing on a certain group of people who aren't in removal proceedings, people who are in the United States currently. And we did that intentionally, assuming that most of the victim survivors of violence that you are working with are going to be people who are in Minnesota in the United States. And so prior removals, so having been deported or removed in the past, or being in this country without authorization and accruing unlawful presence is really common. So I'm going to talk a lot more about that particular ground of inadmissibility in the next set of slides. And then there's miscellaneous grounds, which have fun things like if you are a practicing polygamist, so if you have multiple spouses, if you voted unlawfully, if you are a foreign national, but you left the country to evade the draft. Those are the sorts of miscellaneous grounds that could fall into an inadmissibility. Go ahead on to the next slide, Victoria. Okay, so what does that mean? Let's say you have an inadmissibility, and there are a lot of them. And so if you're working with a victim survivor without status, there's a likelihood that they have some inadmissibility in their history on their record. So what is the impact of that? If you are considered inadmissible, you have an inadmissibility, where it really comes into play is when you are seeking admission to the United States. So if you are trying to enter the United States, if you're at a border or port of entry, you could be denied entry based on the fact that you have an inadmissibility. if you are arrested by Immigration and Customs Enforcement, that could put you in removal or deportation proceedings based on the fact that you have an inadmissibility. Or when you're applying for an immigration benefit, which requires admission, such as a green card, such as a visa, that application could be denied based on the fact that you have an inadmissibility. So it's very important when you're applying for these kinds of benefits that you're being screened for inadmissibility by an immigration attorney, and they're figuring out whether or not those are things you could have forgiven and taken off your record so that you could be made admissible and apply for these benefits. Go ahead to the next slide. Okay, I'm going to talk about this very briefly. The grounds of deportability are different than grounds of inadmissibility. Like I said, inadmissibility comes into play when you're looking to be admitted. So if you're working with a client who has not been admitted, let's say they cross the border without inspection, they cross the border without a visa or without permission, inadmissibilities might really come into play when they're applying for a benefit. However, if you're working with a client who has been admitted, who has lawfully come into the country, they still may face certain grounds of what they call deportability, something that could get them removed from this country if they commit them. They're similar to inadmissibilities. There are some differences between the two things. So this is, again, why it gets complicated, why it's important to talk to an experienced immigration attorney, but I just wanted to put this out there as a concept that I'm not really going to touch on as much today, but it exists. So you can go ahead and move on. Okay, so I am going to talk about unlawful presence. Like I said, this is the ground of inadmissibility that is very common, especially if you're working with victim survivors who are currently in the country without status. It's possible that they may have accrued some amount of, well, it's likely that they may have accrued some amount of unlawful presence. I think I was reading something in preparation for this presentation that said that this is one of the most common reasons that people are in removal or deportation proceedings is because they've accrued some amount of unlawful presence. So in a very important point when it comes to unlawful presence is when the inadmissibility triggers. This can get very complicated, but let's say that you've been living in the United States without authorization for a long time. As long as you never leave the United States, this inadmissibility never triggers. The time that unlawful presence and the accrual of unlawful presence triggers when it becomes an issue is when you've accrued time in the United States without status, and then you physically leave the United States. It's going to be a problem when you're trying to re-enter. So where this becomes a problem is when the 3 and 10 year bar come into play. So I have them listed on here and I explain what needs to be done to trigger one of these bars. So for the 3 year bar, if you have entered the United States without permission and everything is after April 1st of 1997, that's when this law was enacted. So that's when all of this begins. So if someone entered without permission in the last, oh gosh, I decided to do math really quickly, in the last 24 years, they stayed in the US for more than 180 days, but less than 1 year. And then they voluntarily, so not being removed or deported, but they voluntarily left the United States. That would trigger what we call the 3 year bar. So they accrued that 180 days, but less than 1 year of unlawful presence. So they didn't have authorization to be in the US for that period of time. Then they voluntarily left the United States. Now there's a 3 year bar against them, which basically says you're not able to apply for re-entry into the United States for 3 years. Similarly, there's a 10 year bar. So for the 10 year bar, you have to have entered without permission or authorization after April 1st of 1997, stay in the United States for more than 1 year. So it's beyond the 3 year bar time for more than 1 year. And then you voluntarily leave the US or you are removed or deported. At that point in time, if you've satisfied all of those things, there would be a 10 year bar against you. So you would have to wait outside the country for 10 years before you can re-enter or be admitted lawfully into the United States. There are waivers to this where you don't have to end up waiting the 3 years or the 10 years, which is the next part of the presentation that I'm going to talk about. But it's really important when we're thinking about unlawful presence that we have to think about how long they've accrued unlawful presence, because that will determine how long the bar is. And they have to have physically left the United States in order for that bar to trigger. So go ahead and move on to the next slide. Okay, there are certain exceptions. I'm not going to spend too much time on them, but if you are a minor, in this case, under 18 years of age, the clock doesn't start ticking in the accrual of unlawful presence. Similarly, and this can get complicated, but I wanted to bring it up because of the nature of the work advocacy does and we do at Standpoint. If the presence in the United States is in connection to the victimization, so you're working with someone who's applying for a VAWA self-petition or is applying for a T visa, which is a visa based on human trafficking, unlawful presence does not come into play if their unlawful presence and accruing of time without authorization in the US connected back to that victimization. We also don't count time when a person is in deferred action, which is a special benefit you get from immigration. A really good example of this would be the DREAM Act. DACA is deferred action. So when you're in DACA status or deferred action status, that time is not does not count for unlawful presence. And when certain applications are pending, they're very specific applications like asylum or temporary protected status. So not all applications would pause that accrual of unlawful presence. There is a waiver. I'm mentioning it here. I'm not going to get into detail, but it requires that you have a family member who is a United States citizen. And I'm sorry, I put acronyms in here. USC stands for United States Citizen, and LPR stands for Lawful Permanent Resident or Green Card Holder. Just to make the slides a little more concise, I use USC and LPR. USC means citizen, LPR means lawful permanent resident or green card holder. So if you have a citizen or green card holding spouse or parent in the United States who would experience extreme hardship if you had to leave the United States, you might be able to waive your unlawful presence and not have to worry about that 3 and 10 year bar. But I'm going to talk about that more later. So go ahead and move on. There's also a permanent bar. So beyond the 3 year bar and the 10 year bar, there's a circumstance in which you trigger unlawful presence and you trigger this permanent bar, which means there would never be a time in which you would be able to re-enter the United States. Of course, there are waivers to that, there are exceptions to that, but in general, the permanent bar is for people who would not be allowed to re-enter. So in those circumstances, to get the permanent bar, you would have entered US without permission, again, after April 1st, 1997. You stay in the US for more than 1 year. Then you leave the US, or as the other side of the screen, the right side of the screen shows, you were ordered deported or removed. So either you voluntarily left or you were deported. And then you try to come back into the United States. You either come back in the US or you try to come back in the US and maybe you're apprehended at the border. That would grant you a permanent bar from re-entering the United States. Like I said, there are some exceptions. There's exceptions for like people who are applying for specific victim-based applications. So like VAWA, like I said before, you're applying for asylum, if you're applying for a U visa or a T visa, all of those things, you are able to waive this permanent bar. Note, the permanent bar doesn't have as many exceptions as the 3 and 10 year bar. It counts if you're a minor, and there's no family hardship waiver for the permanent bar like there is for the 3 and 10 year bar. This is a lot to take, I know, but I'm letting you know about the permanent bar because it's just more strict and more difficult to have waived than the 3 and 10 year bar that I talked about on the last slide. You can go ahead and move on. Okay, this is a really important slide. And as we go through the next few slides, I want you to keep this slide in mind. So why am I talking about inadmissibilities or waivers at all when we're talking about family-based process? What's the impact on a family-sponsored application? So importantly, like we were saying, to immigrate, you have to have that family relationship. You have to have that petition that Victoria talked about, but you also have to show that you were admitted or that you are admissible. So whether or not the unlawful presence bar comes into play or not will depend on whether or not you leave the US, right? If you accrue all that unlawful time in the United States, but you never leave the United States, that unlawful presence inadmissibility is never triggered. So it's really important to determine when you're doing a family-based process, do I have to leave the United States or can I do the entire process from within US borders? So in order to determine if you have to leave the US or not, you have to look to whether the person was lawfully admitted in their last entry to the United States. So if a person was lawfully admitted, if they came in with valid status, whether or not that status expired or not, they do not need to depart the US to consular process. They already have that lawful admission. So no unlawful presence bar would be triggered. However, if they don't have a lawful admission, if they came across the border without authorization, or they lied in order to come across the border, so it wasn't really a lawful entry, then they have to leave the US in order to consular process in and be admitted. So the term consular process is going to come up a lot in this presentation. What that means is that a person leaves the United States, applies for a visa, goes to the US consulate abroad, has an interview to determine whether their visa is granted to allow them to re-enter the United States. That process of applying for the visa, going for the consular interview, and coming in is called consular processing. So because you need to be admissible, if you weren't ever admitted, you have to leave, go to the consulate, be deemed admissible, and then enter the United States. So in those circumstances, you would be triggering an unlawful presence bar if you've accrued unlawful time in the US. So then you have to look to see if this is something you can have waived or forgiven, or if you have to wait outside the United States until that 3 or 10 year time is up. You can go ahead and move to the next slide. Okay, so I'm going to try and drive this home by going through some scenarios. I'm taking the same scenarios that Victoria did earlier, and I'm just adding some additional facts onto it to talk about unlawful presence in particular. So we're going back to this US citizen daughter. They're filing for their mother, who's from Mexico. So here's the additional facts. The mother entered the United States on March 2nd, 2018 by crossing the border without being inspected. So you'll immediately know she did not have a lawful admission. She did not come in with authorization. So there was no admission. So she is going to have to leave the United States in order to consular process and gain admission to come back in. So when this person leaves the US to consular process, will they be inadmissible for unlawful presence? I'm not going, you can throw it up in the chat if you want. I'm not going to treat this as a quiz. It's hard. So Victoria, give us the answer. Okay, so mom has accrued more than 1 year of unlawful presence. She came in the US on March 2nd, 2018. That means that she has over 3 years that she was in this country without authorization. So when she leaves the United States, because it was more than 1 year, she is going to be subject to the 10-year bar. So in that case, if we're moving forward with this application, I would want to check as this person's attorney to see if there are any waivers of that 10-year bar so that she doesn't have to wait in Mexico for 10 years before she can return. Go ahead and move on to the next one. Okay, so now we're flip-flopping that. We have a US citizen mother who's filing for an unmarried adult, so over 21, daughter who's from Mexico. So in this case, the daughter entered the US on June 23rd, 2015 with a visitor visa. That visa expired on December 23rd, 2015. A lot of visitor visas are only valid for 6 months. She never left the US to return to Mexico, so she fell out of status. Is she considered inadmissible for unlawful presence? So note, I didn't ask if she has to consular process and if leaving the country would trigger it because she entered lawfully. She came in with a visitor visa. So go ahead and give us the answer, Victoria. So no, she's not inadmissible. She's not inadmissible because she entered lawfully, and as long as she never leaves the United States, that unlawful presence will never be triggered. She shouldn't have to leave the United States when her mom is petitioning for her because she has a lawful admission. She doesn't have to leave the US to be readmitted. However, there are circumstances where people choose to leave for one reason or another. There's, a family emergency abroad, they feel like they need to go. If she does leave, it's going to trigger a bar. She may also leave involuntarily. She may leave because she gets picked up by immigration and removed. So in those circumstances, she may also trigger the unlawful presence bar. But as long as she stays under the radar, she's able to remain here while the petition is processing. She won't have to leave the United States to consular process in, and she will never trigger the unlawful presence bar. So don't leave. Go ahead and move on to the next slide. All right, so in this hypothetical, it's a United States citizen sibling who's filing for an adult brother from India. So this brother, when this brother was in the United States, was arrested by ICE, or Immigration and Customs Enforcement, in 2013. They were put in removal proceedings. They were deported or removed from the United States and returned to India in 2015. Then this brother returned to the United States by crossing the border without inspection in 2017. So is this person inadmissible for unlawful presence? So in this case, yes, good job, Janet. Go ahead and provide the answer. So yeah, he is considered inadmissible for unlawful presence, and not only that, but because we had a deportation and a re-entry, he would be subject to the permanent bar. I'm going to talk about waivers a little later. I'm not talking about the waiver in particular that this person would be eligible for. There may be a waiver for this person to get rid of the permanent bar, but it is more difficult. So I wanted to provide this just to show what a permanent bar would look like. Go ahead to the next one. All right, last hypo before we move into waivers. A permanent resident is filing for their spouse, and their spouse is from India. So in this case, the spouse entered the United States without permission recently, so December 3rd, 2020. They remained in the US, they did not return to India. This person was not admitted, so that means to you, they came in without permission, they weren't lawfully admitted, they're gonna have to return to India in order to consular process, get that admission, and come back to the United States. So when this person leaves to consular process, will they be inadmissible for unlawful presence? Go ahead and Yep, they would be. I wanted to show a case where they entered recently, so I could show you the 3-year bar. So this person entered on December 3rd, so they've only been accruing unlawful time for a little over 6 months. So instead of being subjected to the 10-year bar, because they're between that 180 days and less than 1 year, they would be subject to the 3-year bar. But they would be they would trigger that inadmissibility for unlawful presence. They would trigger a bar. So again, talk to an immigration attorney, see if you can get that waived. Speaking of waivers, move on to the next one. There are waivers. So, some of these cases seem really bleak. Everybody's triggering bars left and right and accruing all this unlawful presence, but there are inadmissibility waivers, ways of getting rid of certain kinds of inadmissibility like unlawful presence, so that a person can not have to wait the 3 or 10 years or trigger certain bars. So there are 2 types of waivers that I'm going to talk about today. There's another waiver that I'm not going to talk about today called a 212 waiver, which I'll just touch on briefly, but that is the waiver which may come into play when you're working with someone who has a permanent bar or deportation or removal on their record. So the 601 waivers, the waivers I'm going to focus on today are the traditional I-601 waiver and the provisional waiver called I-601A. If you've ever worked with an immigration attorney, we're super annoying because we talk about things in terms of form numbers. So we'll just call it like a 601 waiver, a 601A, and we all just assume you know what we're talking about. It's super obnoxious, but that is why, because all of these forms relate to specific waivers or specific kinds of applications you're applying for. So we're going to talk about the traditional 601 waiver and the provisional 601A. The traditional 601 waiver is more versatile. So not only can it be used for consular processing, which is how I'm going to talk about it today, but it can also be used for people applying for green cards or people who are in immigration court. It can waive multiple grounds of inadmissibility. Actually, a lot of the grounds of inadmissibility that can be waived through the I-601 waiver. I should have maybe broken it apart this way. I'm going to compare the two. So what it waives for an I-601 would be multiple grounds of inadmissibility. A 601A provisional waiver, however, can only waive the 3 and 10-year bar you get with unlawful presence. That's it. So the 601A or the traditional 601 waives a lot more things. The 601A only waives the 3 and 10-year bars. What does it require? The traditional 601 waiver requires hardship to a qualifying relative. For 601 waivers, that means a U.S. citizen or LPR, lawful permanent resident, green card holding parent, spouse, or child. For 601A waivers, it's a little bit more limited. It does require hardship of a qualifying relative, but it only counts for U.S. citizen or lawful permanent resident parents and spouses. So you'll notice that if you're a parent, it does not count for 601A waivers if you have a child who would experience hardship. Only a U.S. citizen parent, U.S. citizen or green card holding parent or spouse would qualify for a 601A waiver. And then the timing of it, this is what really distinguishes the 601 traditional waiver and the 601A provisional waiver. The traditional waiver, you would need to leave the United States to consular process in. So I'm going to go over a timeline that's going to make this a little more clear. But for a traditional 601 waiver, you would have to be a person who would need to consular process by leaving the United States. You would then apply for the 601 waiver, wait for that waiver to be approved, and then come back in. The reason that the 601A provisional waiver is so awesome is because you don't have to leave. Let's say you would have to leave normally. You don't have admission, right? But you could potentially get that unlawful presence, that 3 and 10-year bar unlawful presence waived while you're in the US. So you'll never trigger it because you'll never have to leave the United States in order to consular process, and you'll get it waived. So you don't have to leave. You remain in the United States while it's decided. If it's approved, you no longer have to worry about the unlawful presence. You can leave to go to your consular interview and come right back in. So it's going to make more sense, I think, when we do the timeline in the next slide. Okay, so this is the process of a traditional I-601 waiver. So family member is going to file that petition, that I-130 that Victoria was talking about. Once that petition is approved, you would file a visa application. Then that non-citizen needs to leave the United States to consular process back in. They would attend their consular interview. At that point in time, when they're at the consular interview, the official who is interviewing them is going to identify inadmissibilities. So they're going to say, okay, you are inadmissible because you have this on your criminal record. You're inadmissible because you've accrued this much unlawful presence. And maybe you're inadmissible because you had a false claim to citizenship. These are your 3 inadmissibilities that we have identified. You can then go back to your attorney, file that I-601 waiver asking for those 3 grounds of inadmissibility to be waived, to be forgiven. The kind of crappy part of the traditional I-601 waiver, however, you're already outside the US. You went to your first interview, you filed this waiver, you're still outside the US. Now you have to wait for that waiver to be approved. Right now, I-601 or I-601 waivers are taking over a year to process. So that means you would have to say goodbye to your family member to leave the US to consular process back in, but you're going to have to wait outside the US while that waiver is being processed and decided. If it is approved, you get to attend a second consular interview where all of a sudden those inadmissibilities that were identified would have been forgiven, and hopefully everything would go well at your consular interview. They would allow you to enter the United States. If the 601 waiver isn't approved, it is appealable. It is something that you can refile, but again, that would take more time with that family member outside the United States. So that's the general process of a 601 waiver. Go ahead and move on to the next one. All right, so this is the 601A waiver. This is why this one is kind of great. So in this one, the family member files that I-130 petition. Again, that part that Victoria talked about. Let's say that you've talked to an immigration attorney and that immigration attorney said, listen, I don't think you have any other inadmissibilities on your record. The only thing you have is that you've been living in this country without authorization for 6 years. So you've accrued unlawful presence. You would have a 10-year bar against you. We're going to try and waive this in the United States so that you don't have to worry about triggering the bar when you leave the consular process back in. So as soon as we get an approval of your petition, we're going to file an I-601A waiver asking immigration to forgive that amount of unlawful time you accrued in the United States. You wait in the United States for the I-601A waiver to be decided. If it is approved, at that point in time, you would depart the United States to attend the consular interview. Here's the kind of caveats that make this a little bit more complicated. So if the 601A waiver isn't approved, the nice part is you haven't left the United States, so you don't have to worry about refiling and waiting outside the US. You can appeal an I-601A waiver. It's not appealable. So the only thing that you can do is you can refile it. Or you can decide maybe a 601 waiver would go better and we'll leave the US and do it that way. Or you may decide that this is not worth it right now. I'm going to wait and file this whole process at another time because I don't want to leave the US. I don't want to trigger a bar. So it gives you a little flexibility to decide what you want to do. Another caveat is if you leave the United States with this I-601A waiver, you think that you've gotten everything waived, that you hopefully talked to an attorney and the only thing they identified was that one inadmissibility where you stayed in the US without authorization. You attend your interview abroad and the interviewing officer identifies other inadmissibilities that you did not waive. So let's say you have an inadmissibility, you have something in your criminal record, or you've committed immigration fraud in the past, and they've identified this at the interview. The I-601A waiver doesn't waive that. The only thing it waives is unlawful presence. So if they're identifying other inadmissibilities at the interview, they're going to revoke your I-601A waiver, and then you will need to file a traditional I-601 waiver abroad and wait all that time while that processes. So again, it underlines the importance of talking to an experienced immigration attorney and making sure that they are thoroughly analyzing the case to make sure there aren't other inadmissibilities. But let's say they go to the interview abroad, no other inadmissibilities pop up, you already have the unlawful presence waived, and so you should just be able to attend your consular interview and re-enter the United States. It shouldn't, assuming everything goes well with this process, the amount of time that you're departing and re-entering the United States is relatively short. You can go ahead and move on. Okay, so when I'm talking about a waiver, one of the things that I mentioned is that you have to show hardship to a U.S. citizen or lawful permanent resident, spouse, parent, or child in the case of an I-601 waiver. I'm going to talk a little bit about what hardship means. So again, remember, when we're looking at these two waivers, we're looking specifically to the qualifying relatives. So for a traditional I-601 waiver, it can only be for U.S. citizen or lawful permanent resident, spouse, parent, or children. 601A waiver is more restrictive in that it's for U.S. citizen or lawful permanent resident, spouses, or parents only. The hardship that you would need to prove that you're eligible for a waiver needs to be, and they say specifically in the statute, it needs to be more than just family separation or financial hardship. So they're looking for a little bit more. In particular, they're looking for emotional or psychological trauma. They're looking for potential loss of employment, loss of education, maybe loss of medical care, or other severe life changes that would happen to that family member. Another thing to note is that these waivers are discretionary. Discretionary means that USCIS, that U.S. Citizenship and Immigration Services that Victoria was talking about, isn't required to grant waivers. It's discretionary. So they get to choose whether or not your application warrants approval or not, whether or not you've proven a hardship, whether or not you've proven a qualifying relationship. So that means that immigration has to be convinced in order to grant your waiver. Another reason why working with an experienced immigration attorney is really important. Before we get into the last set of hypotheticals, I was telling Victoria yesterday that I think I had just become an attorney. 2013 was when I-601A waivers were created. So I was working with this married couple, and we were just now learning about the 601A waiver. So when we started working with them, we were anticipating that her husband was going to leave the country and potentially remain outside the country for a certain period of time. They wouldn't know for sure if the waiver is going to be approved because it has to be applied for abroad with the traditional I-601 waiver. When the I-601A came into play, though, I was telling her, well, now if we can prove hardship to you, he won't have to leave the country, potentially not knowing about whether or not his inadmissibility is waived. The only thing he had was unlawful presence. She had some severe anxiety around him leaving, some other depression and other mental health things going on. And so the ability for her to know whether or not his inadmissibility was waived, to know how long he was going to be leaving and coming back in, was a huge benefit to her. So it was like a real life situation where I saw how beneficial the I-601A waivers can be for family members. So now I'm going to jump into hypotheticals to see how these waivers play out in real cases. Okay, so we're going back to the same scenarios. You can try and chime in. Again, you don't have to, but if you want to chime in on the chat. So we're going back to the scenario with the U.S. citizen daughter filing for the mother in Mexico. Remember, she entered the U.S. By crossing the border without being inspected on March 2nd, 2018. So we need to determine, because again, there's no admission here, so she would have to leave the United States to consular process in, but if she could apply for a 601A waiver, she could maybe get that unlawful presence taken off her record and not have to leave. So I'm wondering, in this case, is a mother from Mexico eligible to apply for a 601A provisional waiver with a U.S. citizen daughter? Victoria, do you want to go ahead and give the answer? All right. So if you remember from the slide previous, for 601A waivers, it has to be hardship to a U.S. citizen or lawful permanent resident spouse or parent only. So in this case, the mom has a U.S. citizen daughter in the United States, but children are not, hardship to children would not make you eligible for an I-601A provisional waiver. So she would not be able to apply for that or get her waiver approved in the United States. I did put on here, it's possible that she has other family members here that aren't part of this scenario. We don't know. So maybe she does have a parent, or maybe she does have a spouse in the United States who would experience hardship. If they do, then we could add that into the waiver and apply for a 601A. But let's assume she doesn't. She only has her U.S. citizen daughter. Is she then eligible for the traditional I-601 waiver? Go ahead and give us the answer. Yeah. So yes, if she can show hardship. So traditional I-601A waivers include U.S. citizen and LPR, spouses, parents, and children. So in this case, because she has a U.S. citizen daughter, as long as she can show hardship to that U.S. citizen daughter, she would be able to apply for a 601 waiver. But she would need to leave the country, attend her consular interview in Mexico, have that identified as an inadmissibility, and apply for the 601 waiver at that time. So go ahead and move on to the next hypothetical. Okay, so next one is a U.S. citizen mother filing for an unmarried adult daughter from Mexico. So if you remember, this is the person who entered with the visitor visa. So in this case, if she never left the United States, her mom would be able to petition for her and go through that entire process without ever worrying about triggering that unlawful presence inadmissibility. However, in this case, I am, oh, did I not change it? I think I thought I had changed it to what if she had left. Do you want to click forward? Oh, here we go. But what if she does leave the United States? I'm not reading my own slide. Because she was lawfully admitted, she would not need to, but what if she does leave the US? What if she has to leave because she has a family member who's sick abroad? So even though we've told her immigration attorney told her, her advocate told her, don't leave the United States, she left the United States. So now we want to look to see if she is eligible for that traditional I-601 waiver. And because she has a US citizen mother in the United States, if she can show hardship to her US citizen mother, she would be able to apply for the 601 waiver abroad. Go ahead and move on to the next. All right, this one is a US citizen filing for an adult brother from India. So in this case, this was the person who was arrested and deported in 2015, then again re-entered without inspection in 2017. This is the one where the permanent bar came into play. So if you remember from what I said a few slides ago, is this person eligible for a 601 or 601A waiver? Right, go ahead and give us the answer. So neither. There's a permanent bar. So there may be, like I was alluding to earlier, another waiver called an I-212 waiver that this person might be eligible for, but this person is not eligible for either 601 waiver because they would only waive the 3-year and 10-year bars. So they would need to speak to an attorney to see if they have other options. Go ahead and move on to the last scenario. Here we're talking about a permanent resident or green card holding spouse filing for their spouse who's from India. In this case, the spouse entered without permission recently, December of last year. They remained in the US and they didn't return to India. So is this person eligible for that provisional I-601A waiver where they would not have to leave the United States in order to get the waiver approved? Victoria, go ahead and give us the answer. So yes, this is very much like the circumstance I was talking about, one of the first cases that I had worked on. This person does have, the amount of time that accrues for the 3-year bar, but because they have a permanent resident spouse, so U.S. citizen, permanent resident spouse or parent, they have a permanent resident spouse living in the United States. So as long as they can show hardship to their, and I'm sorry, I wrote USC, but I should say permanent resident spouse, and they have no other inadmissibility. So the only inadmissibility they need to waive is that unlawful presence. They should be able to apply for that provisional waiver, get it proved here, and only have to leave the country for a short time to go to their consular interview and come back in. So go ahead and move to the last slide. This is going to take a hard pivot because that's all I have to say about the waivers. But I do just want to remind folks, so we are talking this whole presentation, we talked about the family-based process, we talked about inadmissibilities and waivers. There are other types of immigration applications that are victim-based. So there's VAWA self-petitions, which are available to spouses, children, and parents. So spouse, if you have an abusive green card holding or citizen spouse. For a child, so under 21 and unmarried, if you have an abusive US citizen or LPR, lawful permanent resident parent, or if you're a parent with an abusive US citizen child, you can apply for a VAWA self-petition. The VAWA self-petition, essentially, that I-360 VAWA self-petition application replaces the I-130 application that Victoria talked about. So they no longer need a family member to petition for them. They're petitioning for themselves as someone who, assuming that there wasn't abuse, maybe that family member would be petitioning for them, but there is abuse, and so they're petitioning for themselves. There's a lot of grounds of inadmissibility that get waived or that aren't applied to VAWA self-petitions, including unlawful presence. And so for a VAWA self-petition, you would not have to worry about the consular processing process. U visas and T visas, similarly, U visas where they're victims of certain crime, including a lot of crimes related to domestic and sexual violence, and T visas for victims of human trafficking, also have extraordinarily generous waivers that you get to apply for at the same time as you apply for that U visa or T visa application. There is no consular processing typically for these applications as long as you remain in the United States. I said more general waivers, I mean more generous waivers, including for unlawful presence. So that, I think we made it to the end with a little bit of extra time. So is there any other questions?
Yeah, we do have a question. For the VAWA petition, what kind of evidence do they need to give?
Oh, that's great. Could you go back a slide, Victoria? So you would need to prove a few different things. To be eligible for a VAWA self-petition, you have to prove that family relationship. So the spouse, child, parent relationship, you have to prove that. A lot of the cases I work on are spousal relationships. So like Victoria talked about, not only would you have to prove you were legally married, but you would have to prove that that marriage was bona fide. So you'd have to prove that you got married for real with the intent of building your lives together. So evidence that you would need to prove that. You would need to prove that you lived with the abusive person for a certain period of time for a married couple. And then you would have to prove that they experienced what they say in the statute is battery or extreme cruelty. So you would have to show that they experienced abuse. It does not have to just be physical abuse. It can be psychological abuse. It can be financial abuse. And you would prove abuse in all the various ways that we as attorneys and advocates know you prove abuse. So it could be through police reports and records, but it doesn't have to be. It could be through records from a therapist, or it could be through hospital records or affidavits from the person who experienced the abuse, or friends or family. It could be through abusive text messages or pictures. There's a lot of different ways to prove abuse for the VAWA self-petition. And so that's sort of the general requirements you need for a VAWA. Any other questions? You can also throw up a question in the chat box if you want. We went through a lot of things in a short amount of time. Again, remind folks that this is a lot. This is heavy stuff. Part of the reason I really wanted to dig into some of the inadmissibilities and waivers stuff is because I think sometimes when people have family members who are wanting to petition for them or willing to petition for them, there's a perception that it might just be an easy process to get that approved and to get a green card and to get citizenship, but it's more complicated than that, especially if you've been living in the United States and you've accrued that unlawful presence. As you know, there's a various amount of steps you have to go through to figure out how to get that approved, whether or not you have to depart the US, for how long do you have to depart the United States. So when you're working with a client who wants to pursue that option, it's really something that I would recommend doing with the help of a lawyer. You can certainly call Standpoint and we can talk about it as a general option, but it really requires more detailed representation. What's required to be eligible for the, I'm sorry, Jane, I stepped on your toes. So I see in the Q&A box that Janet asked that what is required to be eligible for the I-212 petition. I haven't done a lot of these, so maybe you can speak, Victoria, but I think it's similar to the 601 in that you have to show hardship. But you also have to show a variety of different things, like if you have a criminal history or deportation, you have to provide all of that paperwork as well. Has that been your experience?
Yeah, I haven't worked on very many of them either, but the basics of it are very similar, that you're looking at family hardship as the reason that you're able to waive this, but it's just more difficult to get and kind of a longer process. So it's definitely the kind of thing you want to go through an attorney to talk about, because while it could waive the permanent bar, it might not get rid of everything. So you might be looking at doing a 212 and then continuing on in a different process to actually end up with status, but you would base it on things like a hardship. If someone in your family is disabled and you can't care for them, or if you're having a lot of psychological problems of the person who can't be with you, that all is going to be helpful for really any kind of waiver that you're doing based on family.
Yeah, I think that's a great point. I think depending on what you're trying to have waived, showing hardship and the evidence that you prove to show hardship is going to be particularly important. And like I was saying with the waivers, and the fact that they're all discretionary and you have to convince immigration, another part of waivers is not only showing that this family member would experience hardship, but you're also showing them that, hey, I'm a good person. I'm a person you want to admit and have in the United States. So usually it requires a lot of showing that this person is a person of good moral character. So it's just the way of crafting your argument around whether or not a waiver should be approved. And so for some more difficult cases, you might want to add a lot more information about what a good, awesome person I am. I know I did these things, but look at all these other great things I've done. Excellent question. Any others?
I don't see any coming through. All right. Thank you so much, Rachel and Victoria, today for presenting. As I mentioned in the intro, we will be posting this recording on YouTube, and it will be emailed out to our listserv as well. Thank you everyone for coming today and asking really great questions. And I will now, thanks Janet. I will now end the webinar. Thanks.
Thanks, everyone.